Good morning, everybody.
Good morning, Mr. Commissioner.
Yes,
members.
Mr. Libashe.
We have the same players and teams on the bench there.
Continuation of cross-examination of Mr. Lisa. We're still on the road.
Yes.
I think since we've been away for a couple of days, it could be well to take it with hand. Can you say the evidence? Will you continue to do the truth, the whole truth, and nothing but the truth? Yes,
Chairman, sorry to bear with Libashe, but I do have a preliminary point to raise before the continuation, if you will allow me. The first is, I am told by Mr. Lube, the evidence leader, that certain documents were handed to him on Friday last week with the proviso that they should not be handed to Mr. Holomisa. We would like to ask for a ruling that those documents should be provided to Mr. Holomisa. And the second is, we have, in the course of the preparation, brought two extra documents that would help the Commission. The first is an annual report of 2007 of the PIC, where there are comments that we want the Commission to pay attention to. It is comments made by the chairperson of the PIC at the time, Mr. Mleketi, about the PAIDF, and comments made by the CEO of the PIC at the time, Mr. Brian Molife. That would contextualize the answers that were given by Mr. Holomisa. The second document that we would like to introduce is a document called a trust deed of the Harith Holdings Employee Trust. The Commission will recall that in the course of the cross-examination of Mr. Holomisa, questions were asked about who is allocated shares under the employee trust, and Mr. Holomisa's answer was to question why Mr. Muleketi is allocated shares when he is not an employee. So we would like to introduce those documents because they are relevant to the questions that were being asked to Mr. Holomisa, but they are also relevant to the work of the Commission generally.
Mr. Berger.
Thank you, Chair. Chair, I'm going to start with the second issue first, and then I'll go back to the first issue. The second issue in relation to the further documents that my learned friend wishes to hand in. Chair, this, as you're aware, this is completely irregular in the middle of cross-examination to seek to have a conversation with Mr. Holomisa, to get further documents from Mr. Holomisa, and then to hand those documents in whilst he's being cross-examined is something I've never heard of before. My learned friend knows that he should not be having any communications with Mr. Holomisa whilst he's under cross-examination. We were shown those documents for the first time this morning. We have no issue with those documents going in at the appropriate time. The appropriate time would be to hand the documents to Mr. Libba so that Mr. Libba can re-examine, if needs be, on those documents at the end of the cross-examination. With respect, now it's just completely wrong to follow this route. And we asked our learned friend before you came in if we could follow a different route, but clearly he disagrees with us. So we will require a ruling on that, Chair. Chair, as regards the first issue, which is the witness statements, it has been the practice, as we understand it, of this Commission, since it started, that witness statements are only handed out immediately before a witness is about to give evidence. My clients are not about to give evidence. Mr. Holomisa does not occupy the position of a special witness before this Commission. He is an ordinary witness. He has no special right of cross-examination. As matters stand at the moment, and as we hope to demonstrate, Mr. Holomisa has no evidence at all And all that he does is to speculate. So there's no basis upon which he is entitled to special treatment, which is not afforded to anyone else. He will get the statements like everyone else just before our clients are about to testify, unless, of course, the Commission rules otherwise. There is, if I must just elaborate a little bit about cross-examination, there is a provision in the rules, it's Rule 3.7 of this Commission's rules, which gives the Commission and the Commissioner, yourself, the discretion to allow the cross-examination of a particular witness. It would be odd if a person were automatically allowed to cross-examine a witness without an application having been made to the Commission setting out precisely what it is that person wishes to cross-examine on. I can give the Commission a copy of an extract. It's of no binding value, but certainly it's an extract of a ruling by the Zondo Commission of Inquiry, where, and perhaps members of the Commission will recall just from their reading of the media, an application was made to cross-examine on behalf of, now my mind has just gone blank for a second. Oh yes, it was Minister Lynn Brown was attempting to cross-examine Mr. Jonas because of certain evidence that he had given at the Zondo Commission of Inquiry. And the chairperson of that inquiry asked the representative of Ms. Brown, what version is it that Ms. Brown wishes to place or to cross-examine on? And there was no version that could be put forward, just as Mr. Holomisa in this case has no version. All he does is speculate. And the Justice Zondo ruled in that instance that Ms. Brown, she was mentioned, but she was not entitled to cross-examine. So the point is there's no absolute right to cross-examine. It must be motivated by way of a formal application. And then the Commission will have to decide, taking into account the particular facts put forward, whether to allow the cross-examination or not. It doesn't follow that simply because Mr. Holomisa has been cross-examined now, he is implicating my clients, and therefore we've applied for and been given permission to cross-examine him. My clients are not implicating him. My clients say nothing against him other than that all his evidence is speculation. So, because he doesn't occupy the position of a special witness or a witness who's entitled at this stage to cross-examine, our view is, and our submission is, subject to the ruling of this Commission, that he's not entitled to any preferential treatment. He's not entitled to have the documents before everyone else would get those documents. Thank you.
Thanks, Mr. Chairman. Let me just deal with the first issue, which is the question whether or not Mr. Holomisa is entitled to hand in documents. The fact of the matter is that the cross-examination, as it began on Wednesday last week, has taken place solely on the basis of the documents that were handed in by our learned friends. When one inspects those documents, they are nothing more than the bundle that was handed in the High Court in relation to the defamation interdict, and nothing more, nothing less. Secondly, there is a version that is obviously being put to Mr. Holomisa. He is constantly being accused of not having evidence and not having produced evidence. Now, it's quite clear from where we stand that he has produced evidence and he has produced information. But there's no point in debating the extent to which that evidence should be taken into account. But insofar as he is being cross-examined and a version is being put to him, he is put in an incredibly disadvantageous position because he is obviously unable to answer the questions that are asked in a vacuum without the documents. And so he has specifically said he needs the documents. He needs the documents not only to empower himself, but also to empower the work of the commission and to enrich the work of the commission. But thirdly, there is something unique about what Harith is trying to do. They are trying to get this commission to accept an ambush, that the witness must be cross-examined completely blank. And they are entitled to put a version without necessarily putting documents in front of the commission. And so the documents we have, I'll give you an example, Mr. Chairman. Last week, 2 propositions are put to Mr. Olumisa. Proposition 1 is that Mr. Olumisa says there is an employee share trust scheme in terms of which non-employees are allocated shares. That issue is disputed. Mr. Olumisa is told that Mr. Mahlwele was entitled to participate in the employee share trust scheme because he was an employee as CEO. The document that Mr. Olumisa seeks to produce, which is the amended and restated trust deed of the Harith Holdings Employee Trust, shows that Mr. Mahlwele, as put to him, was a participant. But it also shows that not only was Mr. Mahlwele a participant, Mr. Muleketi was also a participant. In other words, it proves precisely the argument that Mr. Olumisa was making, that there were non-employees that were allocated shares in a scheme that was purportedly on behalf of employees. You are now told that he should not make reference to that document. And at the end of the cross-examination, it will be suggested that Mr. Olumisa has lied to the commission or that Mr. Olumisa has failed to back up his allegations. And so, if one has regard to the prejudice that Mr. Olumisa faces, he faces the prejudice of being regarded as an unreliable witness, a witness who's come to the commission without facts, a witness who's come to the commission and basically lied to the commission. And yet, he does have a document that would substantiate his allegation. And now that document, you are being told it should be excluded from the cross-examination. But what is the point then of the cross-examination? The point of the cross-examination, particularly of the Commission of Inquiry, is not to discredit a witness to no end. The point of the cross-examination is to get to the bottom of the truth. We are never going to get to the bottom of the truth if we continue on the basis that is suggested by Harith, which is that witnesses must be cross-examined in the dark and documents must be excluded. This is not a court of law. Any information, clause 3.7 makes it clear, any information, including information that would be inadmissible in a court of law, is admissible to the commission. And it is up to the commission to verify its authenticity. And this witness truly occupies the place of a whistleblower. He's come to the commission and he has said there is something seriously wrong with the transactions and concluded by Mr. Muleketi and his people. And he wants the commission to investigate that. He's now got a document and you are being told to exclude it. So we would submit there is no basis that has been laid for the exclusion of that document. Document number 2, to give you an insight, Mr. Chairman, is the annual report of 2007 produced by the PIC itself. You remember the cross-examination, the way it went on Wednesday. The cross-examination was, there is no link between the PIC and the PAIDF. This was a decision taken by the GEPF. And in fact, I remember Commissioner Marcus specifically asking this question about what is the linkage between the PIC and the PAIDF fund. And our understanding of the cross-examination is this is a decision independently taken by the GEPF. But the annual report shows that, according to Mr. Muleketi, in September 2007, when he was still the chairperson, it shows that the PIC was the sole advocate of the PAIDF, which was created to raise $1 billion for infrastructure development project. It also shows that the GEPF was simply one of the clients of the PIC. The same point is restated by Mr. Brian Molife in the same annual report, showing that the PIC was the key facilitator of the PIDF. It was placed under its Isibaya Fund, which was led by Mr. Mahlwele. So the attempt at trying to create a distance between the PIC and the PAIDF is completely destroyed by the annual report of 2007. And quite apart from anything, this annual report can cause no prejudice to our learned friends because this is a public document. What it does show, for us at least, is to show the connection between the PIC and the PAIDF, and to show that the attempt that was made at drawing a disconnect between the PIC and the PAIDF is simply not credible at all. And so we would submit that there is no prejudice at the handing in of this document. If anything, it will assist the work of the commission. I know my learned friend complains about the fact that I consulted with the witness. Of course, I did consult with the witness, and I did so even during the course of the cross-examination. But that is precisely because of the way in which this cross-examination is being run, where a witness is given no documents and where a witness is being cross-examined completely in the dark. This is a commission of inquiry. All of us are simply trying to get to the bottom of the truth. This is not a court of law. And so in those circumstances, there would be nothing irregular. I mean, he calls it irregular. There would be nothing irregular in consulting with the witness and saying to the witness, you've been criticized in these two respects. Have you got any facts to substantiate your allegations? And the witness producing the facts. And the first thing we do when we get the opportunity is to produce those documents before the commission. So we must always understand the character of the body that we are dealing with before trying to impose artificial rules that are designed ultimately to exclude evidence so that the commission is not given a full scope of what actually transpired. So we would submit that this idea that there's something irregular should simply be rejected. What we are all trying to do is to assist the commission to have as much information as possible and to assist the commission to get to the bottom of who is lying and who is telling the truth. What we cannot allow is where we know that the witness has been misled into making a concession. We cannot allow that to stand without being challenged. And that's why we asked Mr. Olomisa in consultation to produce any evidence that he has, that he relies upon for the employee trust issue. He's produced it. We are duty-bound to bring it to your attention. We asked him to produce anything that would connect the PIC to the PIDF as early as 2007. He did so. We are duty-bound to bring it to your attention. And there should be no artificial attempts at suppressing evidence. That's not the function of this commission. So we would submit with respect, there is no basis for the objection to the introduction of the two documents. They are perfectly within the rules, and there's nothing irregular in consulting with the witness in the middle of his cross-examination in a commission of inquiry whose mandate is to get to the bottom of what actually transpired with public funds. Let me then go to the second issue, which is the question of the witness statements. I didn't know that these were witness statements. I was made to understand that there were documents handed in, and those documents were handed in on the basis that Harith intended to rely upon them at the time it gives its evidence. It is true that as yet we have not made an application for cross-examination, and we will make the application in due course. But we would obviously be assisted greatly by having regard to the documents that they have handed up. We don't know whether or not in the course of the cross-examination any propositions will be put to Mr. Olomisa where the foundation of these propositions is to be found in the documents that were handed in. But if it is intended that there will be propositions put which are founded in terms of their genesis from the documents that were handed in, it is obviously prejudicial that Mr. Olomisa should answer those questions completely blank about the standing of those documents. But nevertheless, the entire debate, Mr. Chairman, you would realize, centers around this idea that Harith is entitled to cross-examine Mr. Olomisa, and Mr. Olomisa is not entitled to cross-examine Harith. They are entitled to tell him that he's lying, is not telling the truth, but they are not entitled to accept the same when it comes from him. They themselves have put Mr. Olomisa in the category of a special witness by demanding to cross-examine him, because they could have done ourselves and themselves a big favor by simply not cross-examining Mr. Olomisa. And so what he is asking for is not something special or unique. He is simply asking for precisely the right that they have asked that it must be exercised against him. And my learned friend says, oh, well, we didn't implicate Mr. Olomisa. You tell a witness that he's lying, and then you say that you are not implicating him. I mean, come on. It's quite clear that Mr. Olomisa is being gravely assaulted in relation to his credibility and his standing. And he is entitled to shoot back. He is entitled to ask the difficult questions about who are the people that are actually lying? Are these not the people that got hundreds of millions from PIC money that should also be subjected to the microscope of cross-examination? So in those circumstances, there's no basis to say that Mr. Olomisa can be cross-examined, but
I thought you were arguing that, or you are suggesting that there will be an application for permission to cross-examine the witnesses, but you are getting into that now.
Yes, I'm simply saying, Mr. Chairman, that in order for that application to make sense, I am entitled to the documents that they have handed in, because I want to see the evidence that they claim that they will be relying upon when they give their evidence. I need that as well for the purposes of the application for cross-examination. I'm laying the foundation for that. And to sum up on this argument, I make 2 points. I say that firstly, the mere fact that they have subjected Mr. Olomisa to cross-examination, regardless of what documents they have handed in, means that I'm entitled to the full scope of the documents that they are handing in. But I'm entitled more precisely because I intend making an application for the cross-examination of Mr. Olomisa. And the reason why this is also important, Mr. Chairman, and thank you for your interjection, because it does point us to the problem that we are faced with. If ultimately I am not entitled to cross-examine Mr. Olomisa, then I am also entitled to object to the cross-examination of Mr. Olomisa, that it should actually stop at this stage. Because if Harith is not prepared to subject itself to the cross-examination, then there is no basis upon which they should be cross-examining Mr. Olomisa. They are only cross-examining him, from what I understand, to simply show that he has no credibility. But that's simply an abuse of this commission's time, because this commission is not interested in whether or not a witness is not credible. This commission is only interested at finding out what the truth is, because for precisely that reason, it is a commission of inquiry. So at some point in time, the mere fact that the Harith has asked to cross-examine Olomisa should now start counting against them. So if ultimately their point is we refuse to be cross-examined, well, then obviously they should not continue cross-examining Mr. Olomisa. And because they've cross-examined Olomisa, then they should accept that they will be cross-examined. And that is why I suggest to you, Mr. Chairman, and the Commission, that I should be entitled to all of the documents that they have handed in, and I should be entitled to read them, even for the purposes of the continuation of the cross-examination. I should be entitled to consult with the witness about those documents. But I will not insist on handing them now because we are in the middle of the cross-examination. But what I will ask for a ruling on is that they should be handed in to Mr. Olomisa.
I don't understand the last bit. What should be handed in to Mr. Olomisa?
They should be handed to Mr. Olomisa the documents that have been given to the evidence leaders. The only point I make is that I will not insist that they should be given to him before the finalization of his cross-examination. What I will ask for is a ruling that they should be given to him.
If I understand you correctly, it's the statements of Mr. Mleketi Mashwele and Mr. Wheatley. Are those the documents that you're talking about?
Mr. Chairman, I don't know the documents. All I know is that certain documents were handed in on Thursday, and I got the information on Friday from my attorney. I only got to know this morning that those documents include statements. I don't know if there were any other objective documents other than statements that were handed in. But if there were statements, then I need the statements.
It's actually statements with some annexures, isn't it, Mr.
The statements refer to documents, yes, and the documents have accompanied the statements. Chair, can I just respond to my learned friend?
Since this is a commission of inquiry, I'll allow you to respond.
Thank you, Chair. And in his presence, yes. The second thing that is astounding is that my learned friend says he is entitled, because this is a commission of inquiry and not a court of law, he is entitled to consult with Mr. Olomisa whilst Mr. Olomisa is under cross-examination. There is a rule of the bar. It's not a rule of court, it's a rule of the bar to which both my learned friend and I belong, that it is improper, it is not allowed, it is forbidden for counsel or an attorney to consult with a witness whilst that witness is under cross-examination, whilst that witness has been sworn and is under cross-examination, which is exactly what the position was on Wednesday. And for my learned friend to say that he was consulting with Mr. Olomisa whilst he was being cross-examined it's just unbelievable to hear that. That is, it is conduct that is simply not allowed of an advocate. I'll leave that for a moment because that's not a matter for this commission. Let me say this. My learned friend repeats over and over again that my clients are refusing to be cross-examined. That is not so. My clients have made it clear that they will be cross-examined by Mr. Libashe to his heart's content. He can refer their statements to his forensic investigators and units. We've said so to Mr. Libashe. They can investigate, and our clients have freely submitted themselves to be cross-examined by the evidence leader, uphill and downdale. What they object to is being cross-examined by my learned friend on behalf of Mr. Holomisa. Let me make this point as well. My learned friend says over and over again that we've accused Mr. Holomisa of lying. I don't believe that I have once accused Mr. Holomisa of lying. What I have put to Mr. Holomisa over and over again is that his allegations are mere speculation, that his allegations do not constitute statements of fact, that his allegations do not constitute proper evidence. I've never once said to him that he's lying. We don't take away from Mr. Holomisa the fact that his agitation caused the creation of this commission. We commend him for that. The problem is that in his speculation against my clients, he has implicated the wrong people. And that's the whole purpose of the cross-examination. Then the other fundamental point is this. We applied for leave to cross-examine Mr. Holomisa because in terms of the rules, if a person is implicated by another witness giving evidence, as Mr. Holomisa implicated my clients, that person is entitled to be advised in advance, which we weren't, but notwithstanding that, that person is entitled to apply for leave to cross-examine as an implicated person, which we did, and we put forward a full and substantiated application, which served before this commission. That application was also served on Mr. Holomisa, who didn't respond to the application. And once the order of this commission was granted, giving us leave to cross-examine, no steps were taken by Mr. Holomisa or his legal team to have that decision reviewed and set aside. In other words, that decision wasn't challenged. It doesn't lie in my learned friend's mouth now to say he wants the cross-examination to stop. The proper procedure, with respect, is that, as I said at the start, the documents that my learned friend got from Mr. Holomisa whilst under cross-examination should have been handed to Mr. Libashe so that Mr. Libashe can deal with it in re-examination. That we should not have had this half-an-hour discussion about facts that my learned friend discovered whilst consulting with Mr. Holomisa whilst under cross-examination. My clients are not saying that those documents should not serve before this commission. But the point is this. Mr. Holomisa is being cross-examined on the submission that he made to this commission on the 20th of March 2019. That is what we applied to this commission for leave to cross-examine. And it is that evidence that I am busy testing in cross-examination. If there are other documents that Mr. Holomisa has, that's for later. But for now, the whole purpose of the cross-examination is to deal with the evidence that he produced, voluntarily, that he produced on the 20th of March 2019. It is that evidence that is being the subject of the cross-examination. Thank you, Chair.
Mr. Libashe, is there anything that you would like to say?
Mr. Commissioner, I'll be very brief. It's not my fight. but I will make certain submissions to try and assist the Commission. First of all, the order granted to cross-examine was an order granted by agreement between the parties. When the application was served on me, I consulted with Ms. General Holomisa, and he intimated to me that he had absolutely no objection to be cross-examined, and for that reason, the order was made by agreement between the parties. With regard to the witness statements that were filed on Friday, with the condition that it must not be made available to General Holomisa, in my submission, the position is somewhat sui generis, in that the parties now before the Commission were involved in litigation in the High Court in 2018. I haven't analyzed exactly all the statements filed, but what I had a cursory look at, it is not much different than the explanations given in 2018 by my learned friend's clients, that there is no substance in these allegations of General Holomisa, and they gave an explanation. So, in my respectful submission, there is really, in my view, no substance in saying at this stage he cannot have access to those statements. And it cannot prejudice, in my respectful submission, Mr. Berger's clients. With regard to the cross-examination, in principle, I'm in agreement with Mr. Berger. It is not for any whistleblower to pitch up at the Commission and say, I've listened to this witness and testimony, and I'm not in agreement, and I apply for cross-examination. So that, in brief, Mr. Commissioner, is my submissions.
I'm going to make a ruling. If it so happens that reasons for the ruling are required, they can be requested, and I'll draw them up. Insofar as the witness statements are concerned, the procedure that this commission has been following is that they are made available to whoever just before the maker of the statements gives evidence. And I don't think we need to depart from that procedure that we've been following. So the statements won't be made available
Mr. Olomisa or his legal advisor at this stage. Insofar as the documents are concerned that Mr. Ngugaitobi applies to hand up, I think the correct procedure would be for the documents to be handed to the evidence leader and for the evidence leader to place them before us if he feels that that is necessary. I'm not going to deal with the question of whether Mr. Olomisa's legal representative should cross-examine the witnesses. That application can be brought at the relevant time. So is there anything that I'm leaving out?
Chairperson, can I request that my learned friend be asked to move his seat to directly opposite me and not remain next to Mr. Holomisa?
I think he's the advisor. I think he's entitled, Mr. Olomisa is entitled, before giving an answer, for him to step in and advise him. I don't think there's anything wrong with that. So I refuse to order him to move.
Mr. Chairman, I mean, this request is completely out of order, to be honest.
No, I've ruled on it. I don't need further argument, Mr. Mugetu.
No, yes, Mr. Chairman, I just wanted to come back to your ruling, but I thought I wouldn't miss the opportunity. Nevertheless, I have handed the 2 documents to Mr. Lube, so it's really within his discretion when to hand them in.
Thank you.
Can I just perhaps then go on record, Mr. Commissioner? It was handed to me, and I've asked the admin staff to place it before the commission. I think it is fair that it is before the commission whilst the witness is being cross-examined.
Any objection to that?
No objection.
Not from us.
Chair, can I just, at the risk of belaboring the point, just get some clarity from the Commission? Is the Commission permitting my learned friend to sit next to Mr. Holomisa so that they can confer during the cross-examination?
I think I need to reconsider that. Can I get time to consider that?
Yes, certainly, because as I pointed out, it is a fundamental rule of practice that if someone is under oath and testifying, that they cannot consult with their legal advisor.
Can I invite counsel to chambers, please?
Certainly.
We'll adjourn for a few minutes.
I'll follow you.
earlier, in refusing to move, as it were, Mr. Ngugatobi from where he's sitting next to Mr. Olomisa, I said that he's entitled to advise the witness, but I'm reversing that simply to say that it's not necessary for him to move, but he cannot advise the witness before answering questions. But of course, as his representative, he can object to unfair and unreasonable questions, and that's as far as it goes. Thank you.
Thank you, Mr. Commissioner. Thank you. Mr. Olomisa.
Yes, sir.
I'm going to ask you, please, to listen to my questions and try and contain your answers to what I'm asking. And hopefully we can move a lot faster than we did last Wednesday. Now, we dealt with the whole issue of the seed capital loan. I'm not going to revisit that. And we dealt with the establishment of the PAIDF as well. Would you concede that it was necessary to form a company to manage the funds invested in the PAIDF? In other words, to establish a company that would be a fund manager?
No, I don't have any objection to that.
And we know that the company that was established as the fund manager is Harith Fund Managers, which we call Harith FM.
Yes, we agree.
And that was set up by Mr. Mahlwele in 2007, January 2007.
Yes.
If you have a look at the replying affidavit in the urgent application, which was Exhibit 1, I believe. Is it Exhibit 1? Exhibit 1, page 289. Do you have it?
What's the number?
Page 289,
Yes.
Paragraph 9.2.
Yes, sir. I see it.
Sorry, I'm just waiting for the commissioners to get
Sorry.
to the same page. Sorry, Mr. Commissioner, is it Exhibit 1 or Exhibit 2?
I think it's Exhibit 1.
It is Exhibit 1, yes. Thank you. And then we also went through it on Wednesday, the manner in which the PIC share dropped from 100% to 46%. You recall that?
Yes, I recall it when you stated it.
Yes. And then in paragraph 9.3, the bottom of page 289, you'll see there the shareholders of Harith FM are listed. The PIC as to 46%, Old Mutual Life 12%, Absa Trading and Investment 12%, and then the HSIST 30%. You see that?
Yeah.
And you see also in paragraph 9.4 that Mr. Moleketi was appointed a non-executive director of Harith FM by virtue of the fact that he was the ex officio chairperson of the PIC at the time.
As I see that.
And that there were 2 other non-executive directors appointed from the PIC to Harith FM.
Okay.
And you're also aware that Mr. Moleketi received no remuneration from Harith FM, or from the PIC for that matter, whilst he was the chairman of the PIC and then chair of Harith FM.
I don't have those facts. That should be verified by the commission.
Okay, you can't dispute that.
I don't have those facts. That's your version. Own it.
I beg your pardon?
Own your version.
Mr. Holomisa, I'm going to ask you, please, just answer my questions.
I've answered your question.
All right.
Thank you.
Let's keep the tone and the temperature down, if you would.
You seem to want to tell us whose temperatures is low and high. Can we also do the same?
Yes.
Then
I
will do so.
don't think it is correct for you to direct yourselves at each other rather than via us here.
You say I must own the version. What I'm putting to you, Mr. Holomisa, is that these are facts which were brought to your attention at the time of the urgent application, long before you made your submission to this commission.
I have a problem, Chairperson, with this continuous reference to the court papers. We have noted an appeal on that process. Few minutes ago, the legal representatives of the Harith said they applied to cross-examine me on the evidence I tabled, on my presentation I tabled here in the commission. On my part, I agreed to come and be cross-examined on that document I presented here. There is therefore a legitimate expectation on my part that the cross-examination will be focused on what I have said in this commission. Because if you continue to go back to the court issues, we have noted an appeal. And that means, therefore, we disagree with some of the points they've argued in court, and also that we don't accept the judgment. It's our right to continue to make reference to that. It's not going to help this commission. You have just said on the 20th, that you applied to cross-examine Mr. Holomisa on what he has submitted into this commission, not into the court. So if I continue to discuss what I've said, I'm appealing, it may end up contradicting myself when we are in another court. So I need a ruling on this issue. I've submitted documents here. I've painted a picture of how this conflict of interest by your clients has been conducted. You still want to take me back to court issues? Sorry, I'm not prepared to take this.
Mr. Holomisa, I think if you are asked about certain facts, it's either you say they are correct or they are not correct, or you are unable to answer those questions. I don't think it is correct to say that you can't go back to the court. If you say that's precisely what I'm going to oppose, or rather to argue against when we hear the appeal, if I'm granted leave to appeal. But if it's a factual issue and you say you don't know the facts, then say so. It's not necessary for this toing and froing. If you don't know that Mr. Moleketi was paid or was remunerated, just say, I don't know about that. Rather than to say, don't go back to the court. You can raise it with us here and we can deal with that. Okay. But if it's a factual issue and you say you don't know, you're absolutely entitled to say, I don't know.
With due respect, sir, I've already said no twice to that question.
To whether Mr. Mlugeti was remunerated?
Yes,
or not
I said I
remunerated?
don't have facts on that.
Yes, Mr.
Thank you, Chair. Mr. Holomisa, I'm not going to answer your questions, but let me say this to make you rest easy. Yes, the urgent application is going on appeal. Well, you have applied for leave to appeal. That hasn't yet been granted. But the issues that might go on appeal or might not are not the issues that we are dealing with here today. Here today, it's a factual issue. And the factual issue is that this replying affidavit was filed, and you read it, and you were aware of it at the time that the court application was argued. That doesn't go to the merits of the court application. Let me continue then.
In the same vein, Chairperson, one can argue and say at the time, I didn't have this information which I've tabled here. For instance, this share certificate, this document which I've tabled this morning. I didn't have that. They didn't even surrender it themselves. And also the annual report, but I've taken note of what you're saying.
Yes, and I will give you an opportunity every time I ask you a question to say whether or not you have such evidence. And if you have, then you'll tell the Commission whether you have that evidence. So let's move on. We know that in September 2008, Mr. Moleketi resigned as the Deputy Minister of Finance, correct?
Yes, sir.
And if you turn to page 292, paragraph 10.2 of Exhibit 1,
Yes, I'm here.
you'll see there that Mr. Moleketi resigned, but he was requested by the shareholders of Harith FM to remain on as the chairman of Harith FM. So in other words, he resigned as Deputy Minister of Finance, and he was requested by the shareholders of Harith FM to remain on as chairman. Do you have any facts to contradict that?
Can you produce documents to corroborate this paragraph?
I'm asking
Or
you
minutes.
a question. I'm asking you the question.
I don't have them.
Thank you.
Yes. These are your court papers, not mine. So you should be helping the Commission and display an
Just give me-
exhibit to
just
say
give me-
these are the minutes.
Just give us a moment, Mr. Olomisa, please.
Mr. Holomisa.
Just give us a
Thank
moment.
you.
because
If I could, Mr. Badger, if I could ask you whether you're in a position to give us the actual shareholding at that time, who the shareholders were, who authorized or requested that the chairperson continue in that role,
if you are able to,
if you're able to do that.
give us that information.
There was a constant, or there were negotiations in play at that point in time where the investors were saying that the management company could not be 100% government controlled. But I think the transfer of the shares only took place in 2009, if my
Yeah,
memory
but that's why I'm
serves me
asking the
correctly.
chair, when the chairperson was asked after resignation to continue, who the shareholders were at that time, who made that request, and therefore, if you haven't got that information now, if we could get it.
Yes.
Mr. Berger, are you saying yes, we will be able to
Sorry,
provide her?
Chair, I will get that information.
Let's
Give us another one.
just to double check, if you look at page 289, at the bottom there, 9.3, you got the shareholders there.
Yes.
Are these the shareholders then
That you are referring to?
that you are referring to?
Mr. Ledika, I'm not sure, because I know that the final shareholding of 46%, 12, and 30%, that, according to my memory, only was finalized in 2009. So I'm not sure that was the position. I can't say. I'll have to get instructions on that.
If I can assist, according to our information, the transfer happened on the 30th of June, 29.
2009.
Nine.
Yes.
And in 2007, the sole shareholder was still the PIC. But my learned friend will confirm that.
Yeah, I think the point I'm making is which shareholders authorized that Mr. Moleketi continue to be the chair.
I will take instructions on precisely who the shareholders were, or who decided or requested that he stay on as chair. And can I continue? And Mr. Mahlwele was the CEO and a director of Harith FM. You're aware of that?
Yes.
Mr. Olomisa, are you aware that Harith FM did not have a stake in the, or was not an investor in the PAIDF?
If my memory serves me correct, the HFM was tasked by the PIC to oversee the project of PADF1, among others. And also, the PADF1 that task was given to the CEO, Mahlwele, who was running this project while he was in charge of his buyer. So it was transferred to Harith Fund Management.
No, I think you're wrong there.
No.
Because the
Okay.
evidence, and unless, sorry to interrupt you, but unless you have evidence to contradict this, Mr. Mahlwele was the head of the Isibaya Fund at the PIC. You're quite
Yes,
right there.
yes.
He resigned at the end of March 2006 to establish the PAIDF. What was then established was a PAIDF Facilitation Trust. We went through this on Wednesday. The PIC paid 17 million rand as seed capital to the PAIDF Facilitation Trust.
Fine.
So that Mr. Mahlwele, as largely the sole employee of the trust, could then go about traveling internationally, finding investors and so on, and ultimately setting up the PAIDF and then HFM to manage the PAIDF. So in other words, what I'm putting to you and asking if you have any evidence to contradict this is that this creation of the PAIDF and the establishment of HFM happened after Mr. Mahlwele resigned from the PIC.
Yes, we know that Mahlwele left PIC. But what I'm not sure of is to whether he was deployed. Because if PIC were to prove to us that Mr. Mahlwele was earning, let's say, 300,000 per month, per annum, just an example, and that while he joined the Harith Fund management, he retained the same salary. Therefore, you would say he was seconded to start this project. But it's only the PIC who can tell us how Mahlwele has been transferred or ended up working at HFSC.
But the evidence that is contained in the replying affidavit tells you, and I'm asking whether you have any evidence to contradict that, it tells you that Mr. Mahlwele resigned from the PIC and moved and was tasked to go and establish the PAIDF.
To make you happy, I note that he has resigned. Next question.
The question is, do you have any evidence to contradict that?
What evidence do you want? The documents will show of the PIC how Mahlwele was transferred, whether he resigned or not. What evidence do you want from me?
I think,
Well,
again, Mr. Olumisa, address yourself to us,
Okay.
Chair and Commissioners.
Thank you, sir.
I don't know what the council, what evidence council requires, and then we can step in.
Can you help me here exactly through your chairperson? What evidence do you want? You say Mahlwele had resigned. I said, I don't have any objection to that. Why do I have to prove that he resigned or he didn't resign?
No, but do you know that he resigned from the PIC to go and establish the PAIDF?
Yes, I have read that in the newspapers.
You see, the point is this, Mr. Olumisa. You engage in speculation. You say, well...
What speculation are you talking about?
No, just let him finish the question, Mr. Olumisa.
You say, well, I see that he resigned, but maybe he didn't resign. Maybe he was deployed. Maybe he was earning two salaries. Maybe he was earning a salary from the PIC and earning a salary from the PAIDF Facilitation Trust, or HFM.
But Mr. Berger, I think I thought you had put it to him that Mr. Mahlwele resigned from the PIC to go and set up the PAIDF.
Yes, that is exactly what
and I'm not sure that, you see, I'm not sure that the way you are questioning Mr. Olumisa, for instance, to say, do you have any evidence to contradict that, rather than to say, do you know that or don't you? Do you have any evidence to contradict that? I don't think he has contradicted anything. The question that you're asking, I would expect him to say, I know or I don't know that. But you are asking him, do you have any evidence to contradict that? Did he contradict that? Or does he contradict that?
Well, he speculates in contradiction of that.
Where?
You have just put to him that Mr. Mahlwele resigned. And you are saying, do you have any evidence to contradict that?
Yes. Chair,
But you put it to him that he resigned. Do you know that or don't you know that?
but Mr. Holomisa claims, or he suggests, and his evidence before this commission is perhaps this happened or perhaps that happened. And in this particular instance, he just said to you now, Mr. Commissioner, he said, perhaps he didn't resign, perhaps he was deployed, perhaps he was earning two salaries at the same time. Now,
Which means I don't really know. You see, you must remember that this is a commission of inquiry. What Mr. Olumisa has done is to place evidence or place information rather than evidence before the commission to say, investigate this. I think this is worthy of investigation. Right, if there are facts that he has placed as facts before the commission, fine, you can cross-examine on that. But the major part of what he has placed before us is that this is information that I have, and I think the Commission should investigate this.
Mr. Chairman, I just want to put one more point to substantiate the issue. What is being put by Mr. Berger was he was tasked to set up the PIIDF. By who, when, what are the documents? Witness is entitled to ask those questions.
Produce them.
The witness didn't ask those questions. My learned friend just asked the question.
Can we
Yes,
proceed?
what I'm saying to you, Mr. Olomisa, if you don't know that this is fact, you are absolutely entitled to say, I read about it, that's the information that I have. Or, yes, I know that is fact.
We'll do so, sir.
Mr. Holomisa, I'm not sure if you answered this question, and if you did, we'll make it clear. But if you look at the bottom of page 290, paragraph 9.6.
9.6.
9.6, right at the bottom.
Yes, sir.
It says, by August 2007, the sum of $630 million had been raised, and the PIIDF was then closed. The investors were. And there you see from 9.6.1 to 9.6.7 are all of the investors in this $630 million fund.
Mm-hmm. I've read about it.
And HFM is not amongst them.
Yes, I see that it's not amongst them.
Do you know whether HFM, or are you suggesting that HFM could have been an investor in the fund?
Why would they be investing in the fund whereas they were appointed to manage the process?
I'm not sure I understand the question, Mr. Berger. Do you know whether they could have been investors in the fund? I mean, what are you actually asking? Because if you say, do you know that they could, whether they could have been, I mean, what answer do you expect?
I'll rephrase the question, Chair. I think from your answer, Mr. Olomisa, you accept that the HFM was not an investor in the PIIDF. The HFM was the company appointed to manage the PIIDF.
Yes, that's my understanding, because the PIC, as the records will show in that annual report we gave you, were responsible for starting this project. So the Harith fund managers were given a task to even go and raise monies from other investors, as you correctly put it earlier on.
Yes.
It would help us, Mr. Olomisa, if you were to say, yes, I know, and end there, rather than, because your further response will raise further questions.
Okay. Thanks.
Yes, and by August 2007, that fund was closed.
I'm not aware about that.
Well, that's what is stated at 9.6. Are you aware that in a fund such as the PIIDF, investors such as, for example, the Government Employees Pension Fund, they commit a certain amount as an investment to the fund, in this case, an amount of $250 million. But they don't pay that amount up front. Do you understand that?
I don't understand.
And that the money is drawn down as and when the various projects require.
I don't know. I don't understand that. That question should be clarified by the people who put money there, that is GPF as well as PIC.
Are you aware that HFM was established to manage a single fund? It was a single fund manager.
Which fund was that?
Have a look at paragraph 9.5 on page 290, which reads, "The purpose and objective of Harith FM was solely the management of the PAIDF. As such, it was precluded from establishing further funds." You see that?
Yes, I see this. Who would verify this is the commission, not me.
You don't know whether that is
No.
correct. But you can't dispute that, can you?
That's a speculative question.
No,
as well.
you personally have no facts to dispute that.
This thing is not been presented by me. It's your version.
Okay.
I disagree with the line of questioning, with your line of questioning through you, Chairperson. I don't know about what he's talking about. I need to be asked on the document I presented here.
Yes. Carry on.
Now, if you look at 291, you'll 9.7 speaks about investors not being required immediately to pay over the full amount of their commitments. You see that? 9.7 on page 291.
Yes, I see that.
And then you'll see at 9.8, it is described how the investors participated through an investment committee.
All right. I see that. What's your case?
All right, now, have a look at 9.9.
9.9.
The statement is made there that the return on investments made by the PAIDF was almost double the amount originally invested. As at March 2018, the GEPF's initial investment of 4.5 billion rand, forming part of the $630 million, was independently valued at 8.2 billion rand. In other words, the investment of the GEPF had almost doubled in value.
So
Do you have any comment on that?
Unless you table the reports in this commission and share that information with us, because some analysts, I'm sure, will come up with a different version to say we have not performed well on that score. So, but we need to check your annual report if you can share it with us. So I don't know. I cannot give you an outright answer.
Have you instructed any analysts to value the GEPF's investment in PAIDF 1?
I wish I had money to do so. I didn't.
I can give you the exact figures. Of the $250 million that the GEPF committed, the actual drawdown was $248 million. So it was almost the full $250 million. And that, as at the 31st of March, in dollar terms, that was valued at $279.3 million.
Well,
Mr. Berger, can I ask, what did the witness say in his statements in relation to that issue?
The witness said in his evidence before this commission that his information was that the investments were actually doing poorly and that they had lost money. Is that is your evidence, not so, Mr. Holomisa?
It's my evidence, and the commission has got the tools to verify the authenticity or otherwise of that information. They should be having asset managers as part of that toolbox to check this information.
Let me refer you to the evidence you gave before this commission. At page 22 of bundle, Exhibit 2, Chair. It's the transcript of the 20th of March 2019. Do you have that before you, Mr. Olomisa?
I don't have it. You can read it for me.
No, I think it's important that you see your evidence.
Okay.
Sorry, can you just give us the reference again to where in Exhibit 2?
It's Exhibit 2, Commissioner, page 22, paginated page 22. It's also at the bottom of the page, it reads page 4 of 29. And at line 4, you say, many people, including myself, were concerned when reports started surfacing about the possible depletion of the government employees' pension fund, which could negatively affect hundreds of thousands of retired and current employees, which include military and police personnel, correctional services employees, teachers, justice personnel, medical practitioners and nurses, as well as all other government officials. Our interest in the matter was sparked when we received an anonymous tip-off that something untoward was happening with the management of the PIC and by implication the GEPF. And then if I can refer you to page 28, paginated page 28 of the same bundle, line 14, you said the following, Mr. Olomisa. You said, yes, one other transaction that needs careful scrutiny is the Pan-African Infrastructure Development Fund, where these monies are invested. That is the pension monies of the workers. We are told this was delegated to a company called Harith, and Harith, according to the documents I've given you, and also possible the leadership of the PIC, could be in a position to give more details as to where in the continent are these monies invested under this Pan-African Infrastructure Development Fund. Can we go and do an inspection in loco of these areas where the monies are invested? Are they invested in railway lines, properties? What is it exactly and what are the returns? Because according to our information, in terms of the current value, the estimate is around 8.2 billion, and our sources are telling us that it is underperforming. So we need clarity. Perhaps the people who are experts on that can make calculations. So I hope I've clarified it. That was your evidence.
That's my evidence, and the answer to your question is contained in what you have just read.
Are you talking about paragraph 9.9 on page 292 of Exhibit 1?
Yes, I'm talking about the need for experts to verify this. Last week, for instance, through you, Chair, I raised the issue of certain figures which are declared in rands as part of performance of these investments. And I've said, this was a dollar transaction. Why is it not in dollars? But I'm sure the asset managers around your team can assist us on this. This is a technical issue.
The point, Mr. Olomisa, is this. When you gave evidence before this commission on the 20th of March, you suggested that you were in possession of information which suggested that the investment of the GEPF was underperforming, and in fact that the GEPF was being depleted by its investment in the PAIDF. Correct? That was your evidence.
That was my evidence, and I still stand by it. And if you want me to sit down with your assessors, I can go down with the work I've done.
But when you gave that evidence to this commission, you failed to bring to the attention of the commission that you were aware that according to the people involved in managing the PAIDF, they were saying that the GEPF's investment had almost doubled in value.
No, that was not my version. That was not my brief. It would have never been my brief.
You just didn't think it...
Why would I have to say that? I'm entitled to present my own version.
Well,
you
because...
convince the commission that this fund is performing and prove to us. Then we're going to call the PIC and other people to verify that.
All right, let me just ask you this on this point. You did not think it necessary to advise this commission that according to the people who were managing the fund, the value of the GEPF's investment had almost doubled. Instead, you suggested that you were in possession of information that the value of the GEPF's investment had been depleted. That was your evidence.
Well, I'm sorry to say this. The version, the testimony I tabled, I presented here, I didn't have to cater for what we were saying. I based on what I have researched. You are avoiding a question why this money is declared in rands and not in dollar terms as per the investment. Why are you not answering that?
I'm sorry, can I interrupt this a little bit? Please excuse me for that. I'm going back to, Mr. Berger, to your point on page 22 of what the General is saying. He doesn't mention the PAIDF at all there or any specific investment. He is saying, as I've read this and understood it to be, that generally there's concern about what is happening in the GEPF. And if you looked at the recent actuarial releases that have been done, there is cause for concern that has been put there as to what is actually happening between investment income and contributions of civil servants to that. I didn't see that and I didn't read it, and it doesn't mention the PIDF at all. It is referring to, as I read it, a general situation that is page 22, the points that you actually read out, refer to the general concern about the GEPF's funding. That's how I've read that. Secondly, when you look at what you're raising on point 9.9, the question does arise, why would you give figures in rand terms and say this has more than doubled when in actual fact in dollar terms over 2007 to 2018 the profit is $31 million. I'm not sure that that is a great return on investment of $250 million. That is the whole fund. That's not just the GEPF money.
No, that's
Right.
the GEPF's money.
Even if it is the GEPF money at $31 million over 7-8 years, I wouldn't have thought that shoots the light out. So I'm just asking that this is misleading to say it has doubled in rand terms because it doesn't take account of the rand value and what is happening to the rand. So, and I don't think that's a point necessarily here. It comes up quite a bit where you use dollar-rand interchangeably, and we'll need to deal with that as the evidence gets presented.
Yes.
Because it does create a different picture. But I'm raising the question of your issues here because this does not, General Holomisa was not, in my reading of it, referring to the PIDF at all, but a general concern.
Commissioner, there's no doubt that when Mr. Holomisa refers to the depletion of the GEPF, he's speaking about it in the context of its investments in the PAIDF. That has been his evidence throughout. If you look at page 22, he talks about possible depletion of the government employees' pension fund. And if you read that with page 28, he's saying, we are told that this was delegated to a company called Harith. That's line 16, 17.
But that's not the only issue that General Holomisa has raised. Yes, 28 refers specifically to the PIDF and what is happening with Harith, but in terms of page 22, he's making a general point because he's raising, as I've read his testimony and heard his testimony, it's not the only issue he's raised. He's raised a number of investments, PIDF being one, Harith being one to be looked at. I'm just making the point that when he's making the evidence on 22, it comes later in 28 where he's very specific, right?
Yes.
But it is in the general context of a concern around what is happening in the GEPF.
Well, the only link to my clients and the GEPF is their management of the PAIDF.
Certainly, and therefore your reference in page 28, I think, is correct, but not necessarily on page 22. It's different points.
Well, I
mean, I'm just looking at it from the question of what I've heard from him. So all I'm raising is that I would like the consistency of, if it's a dollar investment, a dollar return, because I think that should be the actual evaluation that is possible, and that will need to be done as we go through the witnesses. And that the general point about GPF is one thing, the specific on page 28, I accept.
When my clients give evidence, they will give you both the rand and the dollar.
No, if it's a dollar investment, I want dollar returns.
Yes, yes.
If it's a rand investment, rand returns.
In
that context, thanks, but in that context, I would also want to be sure, because it does come up and obviously we're going a little bit beyond this cross-examination, which is not the purpose of it, but we're taking as given the question of the shareholding and the investors, which comes into question at a later point in time as to who was actually there. So at this point in time, we're accepting what is in the report for the purpose of cross-examination.
Yes.
Not necessarily for what occurs later.
No. With respect, Commissioner, that's correct. This cross-examination is on the basis of the evidence presented by Mr. Holomisa against the backdrop of the information that he had at the time. What comes afterwards will enable the Commission to make final findings of fact. But certainly, you're not being asked to make findings of fact on the basis of the cross-examination. This is part of a larger whole.
Can I also put...
Sorry, my other colleague would like to say something.
Can I just check something? What is the reporting currency in terms of the money that the GEPF give you guys? Because that is the money that the GEPF will get back. What is the reporting currency? Is that the rand or the dollars?
Mr. Commissioner, I don't know. Mm-hmm. I could speculate, but then I would be doing the same thing that I'm accusing Mr. Holomisa of.
Because if it's dollars, you must tell us returns in dollars. If it's in rands, you must tell us returns in rands.
Mr. Commissioner, the purpose of this aspect of the cross-examination is to illustrate to the Commission that when Mr. Holomisa came to testify and to impute certain, certain unlawful conduct to my clients, in particular in this regard, Harith and Harith FM in particular, he sought to draw a link, we would argue, between Harith's management of the PAIDF and the possible depletion, as he put it, of GEPF funds, because the GEPF was a significant investor in the PAIDF. And what he ought to have said to this Commission, and which is what we are bringing out now, what he ought to have said at the time was, there is another view, because he doesn't have the facts. He's speculating, and in that pool of speculation, there's another view that, in fact, far from the funds being depleted, the GEPF's investment in the PAIDF, as managed by HFM and later HGP, has actually increased in value rather than decreased in value. That's the point. So there hasn't been a depletion, there's been an accretion. Commissioner Marcus says it's not a great accretion. Well, that's something, Commissioner, that with respect you can debate with my clients when they testify. But it's certainly on the other side of a depletion. And to say that pensioners are losing their savings and their money through fleecing and depletion and all of that is simply not true. The investment is there, it's a good investment, and it has appreciated in value. That's the only point that's being made at this point in the cross-examination. I hope I've answered the question.
Fair enough, yeah. Fair enough.
Mr. Chairman, I do want to put one more point on this possible misleading line of questions. One of the documents handed in by Mr. Olomisa in the morning of the day he was cross-examined was a bundle that was, I don't know if it was given any label, but item 11 of that bundle refers to a statement made by the principal executive officer of the GEPF, Abel Sithole. It's item 11 of the set that was handed in the morning of the General's cross-examination. And in the last paragraph, the first column on the left, this is how he's quoted. It says, Sithole says the GEPF's commitment to walk the talk is evidenced by its $250 million investment in the Pan-African Infrastructure Development Fund Phase 1 in 2007 and $350 million in the Pan-African Infrastructure Development Fund Phase 2 in 2016. He points out that the GEPF made these capital commitments directly to the PIDF 1 and 2 and not through the PIC. But the next paragraph is important. It is too early to have a definitive assessment on the financial returns of the PIDF 1 and PIDF 2 closed-end private equity funds, as the investment terms are 15 years with option to extend 2 more years and 12 years with option to extend 2 more years respectively. However, Sithole expects fair returns. Now, the point I make here is that in 2018, the principal executive officer of the GEPF was not as bullish as our learned friends are about these returns. His point was actually we have to be careful before we make a definitive statement on the returns. And he went on to explain where the money is and the risks associated with it. I mean, the first one is the telecommunications, main ore cable. Second one is electricity, Lake Turkana. Third one is transport, the Henry Conan Beatty Bridge in Abidjan. And those were the 4 items. But he didn't say that in 2018 we have generated returns of 8.2 billion rands. He said we have to be careful because this is a long-term investment. So that is a perspective that should be put to Mr. Olumisa as part of the evidence that he has produced before the Commission, in addition to the fact that this is a return, so-called return of investment. In rand terms, this is the point he has made repeatedly.
Chair, I'm not sure how that helps. My learned friend is referring to a newspaper article. From what I just heard from my learned friend, fair returns are expected. Again, that contradicts the view that the funds of the GEPF are being depleted by their investment in the PAIDF. It's not helpful, and again, it's disruptive of the cross-examination. It's not an objection to my question.
You see, I'm not sure that it helps when a witness has said, according to my information, this is supposed to be the position, that when you cross-examine, you then cross-examine him or her as if that witness placed it as fact that that is so. If somebody says, that is my information, one would expect, and I don't want to sort of give advice on how to cross-examine, how not to cross-examine, but I would expect something along the lines of, where did you get that from? How sure are you that that is the correct position? Because the information that we have, or on what the witnesses are going to say when they get here, this is the position. I don't really think it helps to try and cross-examine on issues where a witness says, I have information that this is so. And I'm referring to that precisely because the commission is the entity that has been asked or mandated to inquire into whatever information comes to us. So I think it is, you're sort of making it difficult to cross-examine a witness on issues where he says, I have information. And if I remember correctly, on a number of occasions he would say during his evidence, and I asked the commission to go and verify that, because it doesn't really have the correct facts, as it were. This is the information that I have. And so that's the line of cross-examination that one would expect when a witness says, I have information. From where? From whom? How sure are you about the correctness of that?
Mr. Commissioner, the difficulty is that in his evidence to this commission, Mr. Holomisa says he doesn't have the facts, but then he insinuates certain unlawful conduct on the part of my clients. He says they could be members of a cartel. They could be involved in unlawful activity. There could be something wrong with the way in which they conduct business. There are conflicts of interest, and so on. And he goes on and on like that. Take a very simple example. I see a person walking down the street who is walking in tattered clothing, tattered shoes, and in my mind, that person is apparently poor. And yet I see on that person's arm an expensive-looking watch. Is it fair to then come to some public forum and say, well, it appears to me that that watch might be stolen? And I'm not saying it is stolen, but it suggests that there needs to be an investigation as to whether that watch is stolen. And the person wearing the watch says no. And the onus then becomes on the person wearing the watch to say, no, I paid for this watch, and here is the receipt for the watch. And then the person who said, well, it looks like it's a stolen watch, says, well, let me cross-examine you on that. Perhaps it's not so that your invoice is correct, and so on. The whole onus is being reversed here, that Mr. Holomisa can come here and throw up allegations and say, I'm not saying that, or he can draw conclusions without putting the facts. So what we're trying to do in this cross-examination, I'm sure there'll be an objection if I were to say to Mr. Holomisa, who are your sources? Who gave you that information? There'll be an objection coming that I'm seeking to disclose the identity of whistleblowers. So what we're submitting and what we're seeking to establish through the cross-examination is to say, when you ask these questions and when you cast aspersions on my clients, you knew that certain statements had been made, whether those statements are factually correct or not, and you ought to have factored that into your presentation to the commission. Because it's one thing to say, my sources tell me that the funds of the GEPF are being depleted. It's another thing to say, on the one hand, I've heard that information, but I must tell you that on the other hand, the fund managers say that in fact the GEPF's investment is secure and has in fact appreciated in value. So that, with respect, is the basis of the cross-examination. But if the commission is of the view that Mr. Holomisa has not brought any factual evidence and that all he has brought is speculation, if that is the commission's view, then we can short-circuit the cross-examination.
We certainly are not in a position to say that all that he said was speculation, because if one says, I have information, again, I must emphasize that the Commission has been tasked to investigate information and to verify or to ascertain whether that is true or not, and then give the President recommendations and after its findings. So what we are doing is to investigate, or what we are supposed to do is to investigate the information that has been placed before us by Mr. Olomisa. Whether he says, this is information that I've got and I'm concerned about it, and I don't think he can be criticized for doing that. It's for the Commission then to investigate. What I'm worried about is to cross-examine on issues where he said, I have information that this is so, and in your cross-examination, to make him appear as if he said that as a fact, that that is so. That's all I'm worried about. So you may continue cross-examination. I will raise an issue where I'm not happy with it.
Thank you, Chair. Mr. Holomisa, do you know when...
Yes, if I can just say that indeed, you know, the people who are mentioned in his evidence are also free to come and testify before court to say that is not so. What has been placed before court, before the Commission thus far is not correct. These are the correct facts. And surely we will take account of that.
Yes, I have no doubt that the Commission will take that into account. But the question is what value, what weight do you attach to Mr. Holomisa's evidence?
That's for you to argue later.
Yes. And that's what the cross-examination is directed at. Mr. Holomisa, do you know why Harith GP was established? Harith General Practitioners. General Partners, I beg your pardon.
The chairperson, the PIC seeded HFM 100%.
That's not my question.
No, I'm giving you a background. Because another person doesn't know this, what you're talking about, HGP. Now, later on, the HFM is left empty shell after the HGP, what is it called it? HGP was established. Transfer the staff, you stripped that HFM completely, its asset, and you transferred them to HGP, right? And that HGP, we want the Commission to tell us how was that transaction done. Because you see the same directors appearing on HFM as well as to the to the HFP. So we want to know, why did you dissolve that? Because the mandate was given to the Harith fund managers to manage whatever fund, as it was mentioned earlier on. But why did you do that?
You were given the answer in the replying affidavit. Let me refer you to page 293.
No, I'm not going to waste my time on that. I've answered you.
No,
you stripped
Mr. Holomisa, I'm
your
asking
clients stripped
Mr.
HFM naked.
Mr. Olomisa?
Stripped those assets.
Mr. Olomisa?
Sorry.
Just wait. Do you remember the question, though?
Remember the question.
Please answer the question.
The HGP was established after you liquidated HFM.
HFM was never liquidated. I
Rather,
don't know where you
after-
get that fact from.
Sorry, after you transferred everything, that management you delegated to HGP.
No,
That's what you did.
Who did that?
That's why I was asking, it was the board director, the directors of HFM who established the HGP.
Well, I think it will help if you say these are the people who did that rather than to say to
Mr.
counsel,
Molegeti
you did
and
that.
Motlele, chairperson of the HFM and the CEO of HFM were part of that exercise to establish HGP. As we speak today, the HFM has got nothing. It's a shell, empty shell, yet they were given a mandate by the PIC. How did it come to this management to be delegated to the HGP? So they need to explain that.
Let me read to you, because you don't seem to want to read it. Paragraph 10.3 on page 293 says, given the limitations of Harith FM.
Excuse me, is that my testimony?
Can I finish my question, Mr. Olomisa?
No, I want to assist you.
I told you it's page 293, paragraph 10.3.
All right.
Given the limitations of Harith FM, it was anticipated that it would be necessary later to make use of a vehicle under which further funds, in addition to the PAIDF, could be established and managed, in contrast to the single fund mandate of Harith FM. For this reason, Harith GP was established, which, as the name suggests, was mandated to manage several funds under a single umbrella. And then what you were talking about when you're talking about stripping is not stripping. It's dealt with in paragraph 11.1. In the year 2012, Harith FM determined to subcontract its management agreement with the PAIDF to Harith GP. This meant that all the active staff and skilled employees of Harith FM were transferred to Harith GP. The transaction required the approval of Harith FM's shareholders, together with 10 investors in the PAIDF, which was duly granted. So when you say that my clients stripped Harith FM to create Harith GP,
What is left now?
I'm not answering your questions. I'm putting to you that is a gross overstatement. And also what you failed to take into account, Mr. Holomisa, is that transfer and transition from HFM to HGP was with the approval of all the shareholders and 10 of the investors in the PAIDF, one of those shareholders being the PIC.
Do you know that, Mr. Olumis?
I don't have that information. But what is coming out clear here is that they set up a fund from the PIC. Then they set up a separate asset management company and awarded themselves both the management contract from the fund as well as the large shareholding in that asset management for free. This commission, when you examine their documentation, I'm sure you will ask those questions. And also the PIC must come up and say how much was paid for this, and so on and so on. This is what is happening here.
You'd like us to investigate that?
Yes, please.
Mr. Chairman, I should also point to this paragraph 10.3 that it should also be put in context. If you go back to the bundle handed in on the last occasion by Mr. Olumisa, item 4, which might shed light on the establishment of these entities. So if you go to item 4, what we see there, the first item is Harith Fund Managers. What it tells us is that it was registered in 2007, and among its directors were Mahlwele, Tesha Stein, Patrick Kuhn, Jacobus Wessels, Barry Groenewald, Roshan Mora, and Ariane Sabania. And the date of the registration is the 30th of January 2007. If you turn over the page, we see Harith General Partners. The date of the registration is the 29th of January 2007. But if you look at its directors, they include Mr. Jabu Mleketi and Mr. Tsepo Mahlwele. If you compare that to what has just been put to the witness at page 293 at paragraph 10.3, the impression can easily be created that Harith GP came after Harith FM, in fact, many years after Harith FM. Whereas on the registration documents, Harith GP predates Harith FM by 1 day.
Sure. Let's look at that. Pure.
I don't know why my learned friend had to interject again. Paragraph 10.3
I think
says,
he says matters must be placed into perspective. If there's a paragraph that supports or doesn't support the paragraph that you are referring to, I'm sure he's entitled to say, but look at so-and-so, Chairman.
but there's nothing, Chair, that I said in paragraph 10.3 when I read it to Mr. Olomisa that contradicts what my learned friend has referred to. And in fact, if one reads further down, paragraph 12.1, it makes it clear that Harith GP only became active in October of 2013.
I'm talking about its registration. It's clear that it was registered on the 29th of January 2007. It was registered by Mr. Mahlwele and Mr. Muleket. And that is a day before Harith FM even came into existence. That's what you should put to the witness.
Oh,
Yes,
so my
Mr.
learned
Muleket?
friend is now telling me what I should put.
Yes. No,
The
carry on with your
company, Harith GP, was a shelf company. It only became active in October of 2013, and that is exactly what it appears from paragraph 12.1.
Chairperson, this is where you begin to trace this issue of conflict of interest. Here is a former deputy minister who was chairing PIC. In 2007, he was still active, and he started this company. Why did he do that while he was still the minister? This information must be investigated, my friend. You are not going to have a shortcut here. I'm sorry for you. We are going to go deep and get to the bottom of the truth.
If again you can address yourself to us here, please, Mr. Olomisa.
Leave it, Brian, that's fine. Do you know how much the PIC paid for its 30% shareholding in HGP? I can tell you it was 30 Rand.
It's 30 rands.
Yes.
So what's your point?
Do you know?
I don't know.
Okay.
Because you are saying it's 30 rand, so you've already told the commission. What's the point?
And you know that Mr. Moleketi was the chairperson and a non-executive director of Harith GP. Is that correct?
Yes.
And Mr. Mahlwele was again the CEO and a director of Harith GP. Correct?
Yes.
And then Harith GP went and established a second fund that we know of, which we now call PAIDF2, which operated in a similar manner to PAIDF 1, which was the original PAIDF. You're aware of that?
Yes.
And you'll see in paragraph 12.5 at the bottom of 294, it says a second fund, which is known as PAIDF 2, in the amount of $435 million, was then raised by Harith GP with the following investors. And you'll see there that the GEPF committed $350 million of the $435 million. That
I
was
see
raised.
your document. Go ahead.
And again, you were told at page 295, paragraph 12.7, well, 12.6, that PAIDF 2 was finally closed to further funding contributions in June of 2016, and the funds invested in similar projects as the inaugural fund. And again, as at March 2018, the GEPF's initial investment of $1.2 billion, which was part of the $435 million, was independently valued at $1.7 billion. Again, I can give you the dollar amounts.
Well, Chairperson.
Can I just tell you?
Okay.
The evidence will be that the GEPF of the $350 million, initially what was drawn down was $87.5 million, and that was valued on the 31st of March 2018 at $102.6 million. And then in February of 2019, the GEPF increased its investment because further money was drawn down, and it was increased to $182 million. But you don't know any of those facts, am I
All
right?
those figures you have mentioned are going to be subjected to scrutiny. Let's leave it there. You have been told already that, and you promised that you are going to consult your clients about those figures. Let's not confuse this process.
Can I just have a point of information, if you have it now or if you can provide? In 1252, you referred to DTD, a net high worth individuals. Could we get the names of those individuals for $35 million? And 12.6, PAIDF 2, similar projects. It would be useful to get the list of projects that are being invested in. That would be then the PAIDF 1, which we've got the list, but the list of investments for PAIDF 2. And if I could just understand it correctly, because this is meant to be, as I understood it, an Africa-wide fund.
Yes.
And if one looked at the investors here, I can't tell you who 1252 is, but the only fund is the Botswana Public Officers Fund, because I understand the African Development Bank fund did not materialize because of technicalities. So therefore, there's a South African, the funding was mainly South African contribution.
I'm sure Mr. Matrele will be able to testify as to the constraints and what he tried to do and what he managed to do in establishing that fund.
Sure, I'm just raising it so that when he does testify, these issues are addressed.
Thank you. Mr. Holomisa, yes, will you then turn to page 33 of Exhibit 1?
33.
Yes, that's your evidence before this commission.
Page 33.
Yes.
Yes, sir, I have it.
You see there at page 33, line 4, you start dealing with the role of Harith.
Mm-hmm.
So at line 9, Commissioner Marcus asked you, when was the seed money granted? This is the seed money of 25 million rand, which was actually 17 million rand. Do you see that?
Yes, I see. Is that the question where Ms. Chilmaka says, sorry, when was that?
Yes.
Yes, sir.
She says, when was that seed money granted? Because in your documents, I can't see when it was granted to Harith. And you said I would have to furnish you with this, the more information on which year was this. But you already knew at the time when you gave this evidence that that seed money was granted or paid in April of 2006, didn't you?
Not the exact figure, perhaps, but everybody knows that PIC helped Harith.
Yes, and you knew from your participation in the court case, you knew that that payment was in April 2006.
So what's wrong with it? What exactly do you want to know? Just rephrase your question. Maybe I didn't hear you.
Well, you claimed not to know.
Not knowing what?
When the money was paid.
No, I don't know which date the money was paid. It's true. But I know that the money was paid. You're wasting our time.
No. Don't comment further, Mr. Olumisa. Please just answer the question, which you have done.
Next question.
Then at the bottom of page 33, you say, the PIC owns a stake in both companies. There is little distinction between the companies, and they appear to operate from the same premises and share a website. Why do you say there's little distinction between the companies? The one company was formed specifically to manage a single fund. The second company was formed so that they could manage another fund. They couldn't manage a second fund under the first company. Isn't that so?
The confusion here comes when you found that these people are operating in the same address. You would have expected maybe that they have different offices, but they seem to be sharing a passage. They seem to be having same directors.
Yes. Is there anything wrong with one company having the same directors? Or two companies having the same directors? Or shareholders holding a shareholding in different companies?
Well, it might not be looking, it might look good to you, but to us, where we want to know what are the returns of these pension monies, but you see that there is a proliferation of companies, but originating from a fund which was paid by the PIC. And the same crew, when you listen to them talking in the media, like after the testimony, after our hearing last week, Whitley, what is his name? Mr. Whitley. Warren, yes, Warren Whitley. He is speaking on behalf of profits made by Harith, yet he claims to be, yet he's a Libashe registered director. I have not seen him, Warren, in the Harith documentation. So there's a confusion by themselves if you listen to them.
Mr. Holomisa, what facts do you have to suggest that there is something improper or that there was something improper in the creation and establishment of Harith GP? What facts did you have when you testified before this commission that there's something improper?
I'm more interested in knowing as to how much was paid in these transactions, which board decided to take or relegate or delegate the work of HFM to the other institution, which is, what do you call it, HGP. Where are the minutes which would corroborate that decision?
You have no facts, Mr. Holomisa.
That's why this is an information which I've collected from your document and I presented to the commission. The commission is going to verify that.
What you know, and what everyone knows, is that the only exposure of the PIC was in the payment of the 17 million rand seed capital. And that has long since been repaid back.
Even that one, we need to prove that it was paid. For instance, I tabled a spreadsheet here where your clients are showing that they are owing almost 700, over 700 million. I showed you last week, and I said this spreadsheet might need an update. But
Yes.
the proof that you have paid that money, you need to produce it to the commission.
Mr. Holomisa, you're getting confused now. I'm not talking about the 700.
I'm sure it's you who is confused. I know what I'm saying.
No, you don't. I'm not talking about the 720 million rand. I'll come to that.
Which you refused to answer last week.
Mr. Holomisa,
Mr.
please listen to
Holomisa.
my question.
Mr. Olumisa, I said, listen to the question and then direct yourself to us here.
Okay, please bring your question.
I'll repeat my question. The PIC paid 17 million and more, came to about 22 million in the end, as seed capital. That was paid to the PAIDF Facilitation Trust. Subsequent to that, Harith FM was established.
Right?
And then subsequent to that, in 2013, Harith GP became active.
Which was registered even before the Harith FM in 2007.
Yes.
What was the motive by these two directors to do that?
You'll find out about that. My question to you is this. You have no facts to suggest that the establishment of Harith GP and the transfer of the management agreement from Harith FM to Harith GP, the transfer of the staff from Harith FM to Harith GP, you have no facts to suggest that any of that was irregular.
The answer is yes and no. Because we have provided information to the commission to verify this transaction. If you want to say I'm wrong in doing so, so be it. I've done it like that. So the onus is on PIC, your clients, and the commission to come up with a final determination as to what was happening in this transaction.
But you see, you go further, Mr. Holomisa. Page 34, line 20. You say the following. You say, so the role of Mahlwele and the Jabu Moleketi as former PIC operatives,
Yes.
it would appear they have gone out to create an empire, as you will see in my submission, where they are involved. And I hope they will be given an opportunity to clarify these issues. But more importantly is to see that there seems to be a conflict of interest here, because later on they get monies from the PIC as and when they want to extend their businesses.
Yes.
And then you say you want to move on to Libashe. Let's leave Libashe out for the moment.
Okay.
Let's deal with Harith. Harith FM and Harith GP. On what basis can you say that Mr. Mahlwele and Mr. Moleketi are PIC operatives? What is your factual basis for saying that?
The chairperson of Harith was a PIC operative. He was the chairperson of PIC, that is Jabu Moleketi. The CEO of Harith was an employee of PIC.
That's what you mean when you say they are operatives, PIC operatives.
What is a PIC operative to you? Someone who was once involved with the PIC.
Well, if you want me to say, I can say, if maybe I should have said the former employees or operatives of the PIC.
You did say former on the record.
Let me check.
You say former PIC operatives.
Yes, they were. What's wrong with that? What's your worry?
And I suppose by using the term operative, you mean an employee?
They were working
chairman.
they were working for the PIC. Or you want to give us a Latin word for that? They were working there.
And it would appear they have gone out to create an empire.
Yes.
What is the empire that they created in Harith FM or Harith GP? Can you explain the empire they've created?
Well, if you look at the spider web, which I have tabled in this report, this one, you will see from here, from PIC up to them getting involved in a number of transactional companies. I think I've outlined in my testimony, where they are also involved in areas like the Libashe charters and aviation finance.
I'm asking you about Harith. Harith.
I'm saying these two gentlemen, former operatives of the PIC, have gone out to create an empire for themselves. Their names are appearing in these companies.
Are you referring to Libashe?
Libashe for what?
You make an allegation.
I'm talking about the two operatives, the two gentlemen. They went out to create an empire.
When they were at the PIC?
When they left PIC, they were already outside. But there is a curious question which we must deal with. What was the aim of establishing this company which was given power to manage the fund from Harith fund managers? Why was it registered whilst the minister was still a deputy, and also he put his name there? What was his interest?
So is that your big point now?
No, I'm just asking.
No, is that your point? Forget about everything else now. Now we're going to the registration of Harith GP. Is that where you're going?
I've answered you, but you may also ask a follow-up question.
Let me try and ask the question again. What is it in Harith FM and Harith GP that makes you say that Mr. Mahlwele and Mr. Moleketi have gone out to create an empire? What is it in the creation of Harith FM and Harith GP that you find offensive or unlawful? What facts do you have to suggest that?
No, but the word or name empire does not necessarily mean anything unlawful.
Except, Chairperson, they're asking, this commission has been established to investigate whether there was any unlawfulness, to put it at its basic, any unlawfulness at the PIC during certain periods. And so the evidence that is put before you, which implicates Mr. Mahlwele and Mr. Moleketi, can only be related to some alleged unlawful conduct on their part whilst they were at the PIC.
Well,
in Mr. Holomisa's subsequent submission, which he handed in last week, Wednesday, in paragraph 1, the very first page, he says, in the first bullet point, he says, it is clear that a select few, by taking advantage of their prior positions and connections at the PIC, have been able to benefit unduly from the public funds held by the PIC. These... Sorry, I'm told that the commission is not there. Okay. These connections have been used to influence the PIC's decisions on loans, funding, and investment. And then in bullet point 3, the PIC has essentially been used as a piggy bank or slush fund for Mahlwele and Moleketi to further their private interests in various companies. The stellar rise, and then he goes on to Libashe as a key player in the investment arena, is testament to the power of major funding from the PIC, or within a few years. These are statements of fact, which Mr. Holomisa has now made before this commission. So my question is, I'll come to Libashe, but as far as Harith FM and Harith GP are concerned, does Mr. Holomisa have any basis in fact to draw these conclusions, which he states as statements of fact?
I don't have any difficulty with that. All I was correcting is the use of the term empire does not necessarily mean it was there unlawfully.
Yes, but I take your point, Mr. Chair, but in the context of all the allegations that are made by Mr. Holomisa, the use of the word PIC operatives going out to create an empire, that's not used in a benign way. There is the sting of unlawfulness attached to this evidence.
Well, certainly it wouldn't be unlawful to leave the PIC and start a fund managing company, certainly.
Well, that is the point of my clients, that there's nothing unlawful. But Mr. Holomisa seems to suggest that there might be something unlawful in there.
Mr. Holomisa, are you suggesting that there is anything unlawful in creating the empire that you refer to?
Yes, if it is not following the regulations. For instance, when we get the document, it's a pity this cross-examination is being done even before I've seen their submission. Because we will want to know whether there were tenders, for instance, when they decided to establish these management funds. And we don't have that information. So, but I hope that when I get that document this afternoon, we will be able to scan it again and possible say, is it in line with the PMFA rules? Because these are public monies. And we are going to insist that they must table every document in this commission. I'm not going to be intimidated by all these questions. Do you have this? Do you have that? I've provided the information and I'm asking questions in certain categories and areas, which your clients will have to answer here. Hopefully you will be sitting at the back that time.
Mr. Berger, my colleague wants to clear up something.
To clarify something here, just in terms of the growth of the group, say, Libashe and the other companies, I mean, didn't the PIC give 2 loans to Libashe to buy the Capitec shares in Coral Lagoon and Libashe, in terms of just the growth of the group, the broader group?
Commissioner, yes, that is quite correct. That's why my question was to draw a line. I will come to Libashe. As far as, and there are 2 Capitec transactions that I will deal with in relation to Libashe. As far as Harith FM and Harith GP are concerned, the exposure of the PIC was in the sum of about 22 million rand, which has long since been repaid. There was no further, and the 30 rand. which was paid for the shares in HGP. There's no exposure, there's no risk on the part of the PIC in Harith FM or Harith GP. The PIC has also not invested any funds in PAIDF 1 or PAIDF 2. It's the GEPF who has done that, and they've done it independently, as I said on Wednesday. Both decisions to invest the 250 million and the 350 million were done independently of the PIC by the Board of Trustees of the GEPF. So when one assesses Mr. Holomisa's evidence, one has to compartmentalize it, because otherwise one runs the risk of just getting a general impression that there's something that is not quite right, but you can't put a finger on where it is. And that's why if you break it down into, let's deal with the Harith companies and see whether there's any suggestion of unlawfulness. And it appears that there's not. Because the only exposure, and that's what this commission, as I read the terms of reference, what this commission is concerned with, is the management of the PIC and the investments undertaken by the PIC and various other related questions. So as far as the PIC is concerned, what is its relationship? What is its exposure vis-à-vis the two Harith companies? So I will come. I promise that I will come to Libashe, and there's a very good explanation for Libashe as well. But I don't want to mix the two if that's possible.
Okay, fine. Yeah.
Thank you.
I think just to make a small point about on what you've said, I think the terms of reference include very particularly the question of governance.
Yes.
And the terms of reference are for the Commission to look into the actions and activities and functioning of the PIC. There may be issues that relate to different entities which are not necessarily the concern of or involvement of the PIC. But in this issue, there is the question of governance, because that is, whether it's real or perceived is a different question. But a part of the question is the perception around, was there something in having a connection with the PIC and then going on to be involved in entities that are created by the PIC. And as the evidence shows, this was done at the mandate and with the authorities of the Minister of Finance and so on and so forth.
Yes.
But I'm just saying, in relation to your point about whether there was malpractice, the terms of the Commission include a very important question on the legal framework and governance. And therefore, in hearing of this nature, if part of the issue is the perception of poor governance or the reality of poor governance.
Yes, but with governance, if there's a perception of poor governance, it might be that all the facts are not known.
I'm not disputing that. I'm saying that's the work of the Commission to assess. Yes. So when you're saying it's only about impropriety, which is what you said at the beginning, and you broadened it later, I'm just emphasizing the question that the Commission's looking at this. It's impropriety, but it also includes a whole range of things, including governance. So therefore, part of what we would be looking at here is how do we address the question of governance, if there has been, I'm not saying there has been, if there has been any concern about governance, real or perceived.
Yes, I'm not sure that Mr. Holomisa can help the Commission on
No, I'm raising it from the point that you raised in relation to the question being only about impropriety, which is what you said at the beginning. And I'm saying it's actually broader.
Thank you. Can I just ask what time the Commissioners want to take an adjournment? Because I'm about to go on to Libashe.
We were looking at 1 o'clock.
Mr. Chairman, can I also raise one point? You see, my learned friend, it's not clear what he was doing, whether he was arguing or not, when he says that it appears that Mr. Holomisa is not able to point to unlawfulness. The last answer that Mr. Holomisa gave was to ask, was the PFMA followed? And if the PFMA was not followed, is that lawful?
I said, I suppose Mr. Olumisa shouldn't be asking counsel whether the PFMA provisions were followed, but rather to give a reply, and maybe counsel will then follow up on that reply.
Thank you, Mr. Chairman.
Mr. Holomisa, to respond to your question, as far as you're concerned, the question is really this. Do you have any information or facts to show that the PFMA was not followed?
In creating these, or the empire, using the
In
term used by
anything
Mr.
that has to do with the creation of HFM or HGP, or the payment of the 17 million rand seed capital, or the payment of the 30 rand for shares in HGP.
The mistake you have is that you are targeting a messenger. What I've done here was to do a research after I've read all these nauseating exposés about the PIC management of our pensions. And I submitted that report to the Commission. And the Commission will verify the authenticity of this testimony which I've presented. And also, you must also know that the Commission itself have got powers to appoint forensic auditors. And also, those forensic auditors will come up with timelines which would paint a picture as to what has been happening in this fund. For you to always ask for evidence, I've provided evidence even this morning about the shareholders. And I asked a question to say, on what basis a chairperson of this entity become a shareholder, yet is a non-executive director? You are still going to deal with these shares. How this share certificate document? What interest did he have here? And it's the same company. These things accrue from the same companies they established while he was the deputy minister.
That document is unsigned, but
That's fine, but it's going to be verified.
Just wait a minute, Mr. Olomisa. But it has a date there of 2015, is that correct?
Yes, we'll check.
Coming back to my original question, I don't know why you find it so difficult to make this concession. But the simple fact...
You're wasting your time. You're not going to get any concession from
Mr.
me because
Olumisa,
I want...
Can you wait for the question? Let counsel finish his question.
Okay.
You have no facts other than the allegations that you contained or that you put into your submission to this commission on the 20th of March. Am I right?
Thank you very much that you concede that I've tabled something to the commission. Let the commission verify whether that is factual or not you.
When you talk about your report that you submitted to this commission, it is the submission that you made on the 20th of March.
Yes.
Is that correct?
If I may address you also.
No, I haven't asked a question.
Address us here.
If I may, Chairperson, through you, if I may address you, Chairperson and Commissioners. You see, when you talk about this conflict of interest, it's written here. It's here in the House. His clients are sharing the same offices, same companies appearing in their website, same address. They even hire together, but they claim to be separate, hire one legal firm. They are here. Thank you.
And that is your evidence of conflict of interest.
We're still going to elaborate on that. Bring us your document, then we'll assess them, which you refuse me to scan.
Okay, Mr. Olomisa, let's move to Libashe. Are you aware that Libashe is a private company?
I'm aware it's a private company established by the former PIC operatives.
Mr. Wheatley is a former PIC operative, to use your words?
Not necessarily all of them, but what is the role of Mahlwele there?
So it seems to be your impression that if somebody was once employed in a government institution or a parastatal or some institution related to government, that having left that institution, forever and a day, that person will be tainted, can't get involved in private business because questions will be raised. Is that what you say?
The problem is that you don't want to address your question in context. The point we have raised here is about conflict of interest, and we have sketched the relationship between these companies and individuals, but you choose to avoid that.
Yes, you've mentioned the
Then
same
you are not
address.
going to get an answer which is like you are asking me to do. I'm afraid I will keep on referring to the relationship they had, then to have a clearer picture. Maybe they didn't brief you properly.
Chair, through you, I'm going to ask, Mr. Holomisa has continuously been insulting me and my clients this morning. I've kept quiet, but he really needs to be called to order with respect. He needs to stop his snide comments and his insulting comments, because I haven't insulted him. I've been polite, and I've asked him questions. This is not the way that a witness who pretends to be attempting to help should go about things.
Mr. Olomisa, please answer the question and don't make comments. But Mr. Berger, I'm not sure that it is correct to say that he is attempting whatever he is attempting, because that now calls for another comment from him. So, Mr. Olomisa, listen to the question once again and answer to us sitting here directly, and limit yourself, please, to the answer.
Thank you, Chair. So I'm not even allowed to give a little bit of background or to qualify that, my answer.
If it's got to do with the question.
But if it's a ballot question, yes or no, then we can finish quickly. If you want a ballot question.
Let's try it.
Yeah.
So, you know that Libashe was established in 2015, am I correct?
Yes, it's fine. We can verify that. It's not important. But there is a company called Libashe.
And initially, it was established under the name of PetroTouch.
PetroTouch, yes.
Pty Limited, you know that.
Mm-hmm.
And that happened in 2015.
Yes.
7 years after Mr. Moleketi left government. 7 years after Mr. Mahlwele left the PIC, correct?
Yes.
And Mr. Wheatley, to whom you've referred, he was never employed by government, he was never employed by the PIC, correct?
Yes.
He was employed by Absa Capital, Pty
Yes.
Limited. And Mr. Mahlwele was one of his clients.
Oh, okay. Didn't know that.
If you'd read paragraph 13.1 at page 295, you would have seen that.
Are you referring to court papers?
Yes.
Okay, I have got some reservation about your court papers, but let's continue.
Now, your issue with Libashe concerns the Capitec shareholding, correct?
I did raise that issue to be investigated.
Yes. And we're talking in particular about 10 million Capitec shares, correct?
I won't be accurate about it. I'll have to check.
And those 10 million Capitec shares were purchased by a company called Coral Lagoon. You know about that company. You've referred to it many times.
Yes, I've seen it. I've read about the lagoon.
And Coral Lagoon had purchased those Capitec shares way back for 30 Rand a share. 10 million Capitec
I
shares.
wouldn't know that.
Well,
Sorry.
you would, because it's at page 295, paragraph
In your court
13.2.
papers.
Yes.
But I've told you and the commission that a lot of water has passed under the bridge since that court case. I've answered.
And then to fast forward on page 296, Coral Lagoon made an offer to the PIC in 2012 to sell the PIC some of its Capitec shares, just under 5.3 million Capitec shares. Are you aware of that fact?
Not aware, but the commission will help us, both of us.
For record purposes, it's page 296 of Exhibit 1, paragraph 14.1. And so, in February of 2012, the PIC purchased those 5.3 million shares for 156 Rand per share.
I'm not going to contest that. That information you have must be verified. You have already submitted those documents to the commission. So let the commission come up with some findings on that.
And it was a provision of that agreement of sale that the PIC would only on-sell those shares to another suitably qualified BEE purchaser.
It might well be, but the commission will tell us.
That's page 296, paragraph 14.1. What's not there, an additional requirement, was that the shares had to be sold within 5 years. But you wouldn't know that either.
No, either. You're correct.
Do you know that that sale was publicly disclosed in the media? It was disclosed through the Johannesburg Stock Exchange news service. That it's called JSE Sends.
Even that one, you will be of good help to the commission if you attach it to them.
Well, you could have also, in your scratch,
No.
in your scratch work, you could have come up with that.
That's not my worry. That line of questioning is trying to cover the tracks of what we have established, what has been going on here.
I'm not trying to cover any tracks, Mr. Olomisa. I'm laying things out chronologically.
Okay, go ahead, sir.
Now, there are three directors of Libashe. That's Mr. Wheatley, Moleketi, and Mahlwele. You're aware of that?
Yes, sir.
And in 2015, Libashe wanted to buy the 5.3 million Capitec shares that were held by the PIC.
Thank you for providing the information, but it will be verified.
And in order to purchase those shares, Libashe had to get funding for those shares. And they managed to get a fully funded deal arranged with Investec Bank. You
Yes,
know that.
I read about that, part of it.
Yes.
Not whole, but part.
And they presented this fully funded proposal to the PIC in 2015.
PIC would corroborate your allegations.
It's also at page 297 of Exhibit 1, paragraph 16.3. Now I must tell you, also in paragraph 16.3, which you might have read at the time of the court application, it says the PIC accepted the proposal at a price of 370 Rand per share, subject to various conditions precedent. It turns out that the 370 Rand was the spot price, but the agreed price was 325 Rand per share, not 370.
You see, Chairperson,
Do you know that?
No, I don't know. I don't know, but I want to assist you. You see, the disadvantage of a court process vis-a-vis an inquiry is that although he, in his answering affidavit, he could argue as he is reading those pages, but the court don't have the instruments to verify those. But this inquiry is far better because we will be able to verify those. For him to expect me to say, do you agree? How will I agree on that? Because even in court, we didn't have the tools to verify that.
I think earlier I suggested that if you know something, say I don't. If you don't know it, just say, no, I don't know anything about that.
You can continue, sir.
So we have a situation where a private company is formed, Libashe is formed. It has nothing to do with the PIC. There's no money from the PIC used to form Libashe. With me so far?
Well, the allegations which I have tabled here will help you to answer that question when the inquiry is cross-questioning or cross-examining the PIC.
In your bundle, which if it doesn't have an exhibit number, Mr. Chair,
Don't think it has.
then can we call it Exhibit 4?
It'll be Exhibit 4.
Thank you, Chair. In the first page of Exhibit 4, Mr. Olumisa,
Which one is that?
you say this: the PIC has essentially been used as a piggy bank or slush fund for Mahlwele and Moleketi to further their private interests in various companies. The stellar rise of Libashe as a key player in the investment arena is testament to the power of major funding from the PIC, all within a few years. Do you see that?
I stand by what I've said. subject to the verification by the commission.
Yes, but you see, you state this as a fact. This isn't a question. This is a statement of fact. And the truth is that you have no evidence to back this up. Let me break it down, Mr. Olomisa. You have no evidence that any PIC money was used to establish Libashe. Am I right? Because it simply isn't so.
Well, I'm sorry. I have asked this commission to investigate these matters, these allegations. I've asked them, and the commission must come up with the finding. But the cost of the shares, around the 2.4 billion was funded by Investec Corporation Bank in the amount of 1.7 billion, and by the PIC in the amount of 720 million. So that would need verification. That's not your job. It's the job of the commission. That's what I've said.
You keep answering something that's not asked of you.
Okay.
Let me repeat my question, Mr. Olomisa. In the establishment of Libashe, there was no PIC money used.
Why would PIC money be used when you're establishing a company?
All right, so you accept that Libashe was established without any money from the PIC. You accept that as a fact
No,
now?
I'm not accepting that. I'm saying it must be investigated. There's that allegation.
You won't accept that, all right?
Thank you.
But you have no facts to suggest otherwise.
I'm not accepting it.
You have no facts to suggest otherwise.
I reserve my comment.
Mr. Chairman, the witness has explained what his concern is. And this concern is not, it's actually supported by what they say in their own affidavit. Look at page 297.
No, Chair, I'm going
Witness
to
says-
object to my learned friend.
No,
That's what the
why?
witness just read.
No.
What are you hiding?
No,
I'm not hiding.
Mr. Olomisa, your counsel is now addressing us. Don't come in.
I'm saying, Mr. Chairman, it is from the replying affidavit of Libashe itself at paragraph 16.5 at page 297, where they say the cost of the shares amounting to 2.4 billion was funded by Investec Corporate Bank in the amount of 1.7 billion and by the PIC in the amount of 720 million rands. So the fact is, Libashe is a beneficiary of PIC funding.
My colleague was referring me to that part as well, that there was 700,000 from the PIC.
Yes, but I'm
720.
talking about the establishment of Libashe. I'm coming to the Capitec transaction. I've asked Mr. Holomisa a number of times now, in the establishment of Libashe, was there any PIC involvement?
And he, if I remember correctly, he said, why should there be that money in the establishment?
Yes. And then my learned friend points the witness to paragraph 16.5, which is not about the establishment of Libashe. I'm coming to what Libashe did in its business.
All right, my colleague needs to ask something.
Perhaps this could be a question of semantics in some ways, because if you look at the documents, is that the PIC funded the Capitec shares twice, 720 million rands, and I think the other one was 1.2 billion rands. So, I mean, in a broader scheme of things, one could say there was some funding of Libashe, you know.
But
Whether you separate establishment versus getting loans, maybe that's legal speaking, but broadly, Libashe was funded by the PIC to buy Capitec shares.
Commissioner,
No, I understand what you're saying. You are saying when it was established, when Libashe was established,
yes,
no PIC funds were used.
yes,
That's what you are saying, and that's
Yes.
what you are putting to him.
yes.
And his answer is The commission will inquire into that and they'll give us the answer.
And I went further to say, Mr. Holomisa has no facts to assert the contrary. And then my learned friend points to 16.5, but that's not what I asked.
Right. You were asked the question, and I think you did respond, Mr. Holomisa. You agree that no funds were used in the establishment of Libashe. You accept that?
I accept that. That's why I posed that question.
Exactly.
Why would you expect PIC to pay you for establishing your company? I don't
That's
know
what I
you...
remember you saying, but your answer is correct. I accept that.
Thank you, Chair. Now,
What's your take? Sorry.
Oh, Mr. Holomisa, no.
Okay.
I read to you that the Libashe presented the proposal. The PIC accepted Libashe's proposal at a particular share price, but there were various conditions precedent. Those conditions had to be met, some time elapsed, and by the time the PIC was ready to proceed with the deal, the share price, the Capitec share price, had risen, according to paragraph 16.4, had risen to 472 Rand per share. But again, I must tell you that's the spot price, and the price that the shares had risen to for purposes of the deal was 461 Rand. So in other words, the share price had risen because of the delay from 325 Rand per share to 461 Rand per share.
So what's your point?
Or you're aware of that?
No, I'm not even...
You see, because...
I'm not even worried about that because what you are asking will be verified by the commission.
You see, you're concerned about the lawfulness, and correct me if I'm wrong, but it appears that you're concerned about the lawfulness of the 720 million Rand loan. Am I right?
Yes, I'm questioning that, but
Right.
the
So
commission must deal with that matter.
If you are concerned about it, one would have expected you to have investigated the reason for the loan.
I didn't go that far to come up with an answer which would satisfy yourself. And
Well,
your client.
it's set out in the affidavit, page 297, paragraph 14. So,
Would this then be a convenient time to take the lunch and adjournment, or do you want to ask a follow-up question?
no, I can continue after lunch. Thank you.
We shall adjourn until 2 o'clock.